Okay, chapter 3, part 5, the defendant's response. So the defendant can admit, deny, or say they're without sufficient information with every factual allegation that the plaintiff has alleged. The defendant can also assert an affirmative defense. Okay, and there are many affirmative defenses. Typically, let's say, for example, the plaintiff is suing for battery. The plaintiff claims that the plaintiff and the defendant were at a party and the defendant punched him in the nose. The defendant can say, it's true I punched him in the nose, but I did so in self-defense because he pulled out a knife and threatened me. Okay, that's an affirmative defense. It admits the allegations but says that I have a defense under the law to those allegations. Okay. Also, the defendant can say, not only do I deny being liable because I have an affirmative defense of self-defense, but after I punched him in the nose, he went out and hammered the windshield of my car and damaged it, so I'm suing him in a counterclaim for that. Okay? In the federal system, the plaintiff has to file a response to a counterclaim called a reply. If they don't do so, then they've defaulted. In Georgia, you do not have to reply to a counterclaim. It just sits there until trial. Okay. Intervention and consolidation. Intervention is where there's a third person who has some interest in the lawsuit and wants to get involved in it. So if you have a 3-car accident and car 1 is suing car 2 and car 3 wants to also sue car 2, car 3 can seek to intervene in the lawsuit. Okay, consolidation is where you have 2 different lawsuits. Suppose again you have a 3-car accident. Car 1 is suing car 2 and car 3 in a separate lawsuit is suing car 2. In that situation, the court may consolidate it because it involves the same set of facts and the same issues of law, and it's more beneficial to the court in terms of time and expense to do it all in one. Okay. So now, at that point, when the complaint and answer have been filed, sometimes the parties file motions or begin filing motions. Now, the definition of a motion is simply a request to the court to do something for you. It can be in writing or it can be oral. The procedural rules say that in most cases it needs to be in writing. Obviously, if you're in the middle of a court hearing or a trial, you can't necessarily do it in writing, so most motions made during trial are done orally. However, most motions made before trial are done in writing. Okay? And so you file your motion, you file what's called a brief, which is your explanation to the judge why you're entitled to that relief you seek in the motion, and then the judge rules. Now, there are certain motions that are set forth in the statutes and in the code, and those are things like a motion for judgment on the pleadings and a motion for summary judgment. We'll be talking about those in a minute. There was something else I was going to say about motions. Other kinds of motions you can just make up. Anything you want the court to do for you, you can make up. You have to be judicious about it, though, because courts don't like to hear a whole bunch of motions, particularly if they're frivolous. So keep that in mind. Okay, so one type of motion is a motion to dismiss. It's usually filed by the defendant, and it's usually filed right after the answer is filed. And basically, the defendant is saying that there's no lawsuit. Either the court lacks jurisdiction, or the plaintiff has failed to state a legal claim. And if the court rules in the favor of the defendant, the lawsuit's over. If it rules against him, then the lawsuit continues. A motion for judgment on the pleadings is where the defendant or the plaintiff, either one, says to the court that, Judge, we don't have to have a trial on this case. All you need to do is look at what's in the pleadings, the complaint and the answer, and there's enough there for you to decide this case. It's very rare, but it can happen. Okay? A motion for summary judgment usually occurs later on in the case after the parties have done discovery. And in that situation, the moving party, whether it's the plaintiff or the defendant, says to the court, Your Honor, based upon the pleadings and the discovery done in this case and affidavits that have been filed with the case with the court, there's no issue of fact. The facts are clear. The court just needs to rule on the law and decide the case that way. So that's a motion for summary judgment. Okay, so these are some of the pretrial motions we talked about, most of these, and the remainder we may talk about as we go along. Okay, keep in mind the statute of limitations. In every civil case, you have to bring the lawsuit within a certain period of time. Typical personal injury claims have to be brought within 2 years. There are some exceptions. There are various statute of limitations. In fact, I once saw a pamphlet which had about 20 pages worth of different statute of limitations in a case. So that's one of the first things you want to usually research, whether you're the plaintiff or defendant, and that is, based upon what claims you're making, what are the statute of limitations. Okay, and they vary by jurisdiction. Also, when does the time limit start to run? Does it start from the time you file a lawsuit? Does it start from the time the action occurred? That can differ in various cases. For example, let's say it's a malpractice case, a medical malpractice case. And let's say your state has a 2-year statute of limitations on medical malpractice. And let's say the malpractice was that you had surgery and the surgeon accidentally left a sponge in your stomach, and you've gradually gotten sick over the course of a period of time, and you don't discover what caused your sickness for 2.5 years. Are you past the statute of limitations? Most states would say no. Most states would say in that circumstance the statute begins to run when you learned or you should have known about the cause of your problem. So you need to keep that in mind as to when the statute begins to run. Okay, so that brings us up to the next section, which we'll start with the next video, and that is discovery, which is a very important area of pretrial practice. Remember again that the magic word for this chapter, chapter 3, is court.